How do I protect my family in the event of my incapacity? I'm James Anderson. I'm an estate planning attorney in Greenville, South Carolina. I've had the opportunity to assist hundreds of clients with this very issue, and we'll tackle that today. And say on my way home to Fountain Inn tonight, if I get in an accident and I am placed in a coma, I can no longer manage my affairs for myself. I can't sign for myself. If I haven't done anything to plan for that, then we can make a pretty strong argument that I've set up the rawest deal of all for my poor wife, Kate. Just because Kate's my wife does not mean that she can step into my shoes and sell my property for me. It doesn't mean that she can enter into contracts for me or deal with most types of third parties on my behalf. Kate will find herself, again, making that arduous trek up 385 North to the probate court, where this time she's probably going to drop at least $3,000 in attorney's fees and court costs, etc., to what in essence amounts to having to sue me in probate court. She's going to say, probate court judge, my husband James, he's incapacitated, he's in a coma. Here's all the gory details, proving the fact that he's in a coma. All this is public record, by the way. I need you, probate court judge, to name me the guardian of James's person and the conservator of his financial estate. And Kate's nice enough, and the probate court judge would probably think so too, and will probably go ahead and appoint her my guardian and my conservator. So now she's going to have a court order showing that she can step into my shoes, sell my property, transact business on my behalf. So that's the end of it, right? Well, no, that's really the beginning. Going forward for the rest of my life or the rest of her life, whichever comes first, she will have to periodically account to the probate court and show what she's done with my stuff. On top of that, the probate court's going to want to see that she's using what I have to take care of me. They really don't want to see that used to take care of her or to take care of the kids or the dog and the cat or to tithe the church or make gifts that I was in the habit of making prior to my incapacity. So that's a pretty big deal. We talk about avoiding probate when someone dies. That's all well and good, but in most instances, living person's probate, a conservatorship, is more expensive, more time-consuming, and more disruptive to a family's financial status quo. Now, for the sake of illustration, let's say that prior to getting in that coma on my way home tonight, that I had a traditional estate plan where I had a durable power of attorney. This is where the power of attorney would come into play. If I've signed this document saying that Kate can step into my shoes and sign for me, sell my property, transact business on my behalf, that could potentially be quite useful. If she takes it to my bank, if she takes it to my brokerage company, if she takes it to third parties that have and institutions that have business with me, insofar as all those people, all those places, all those institutions accept that power of attorney, great, mission accomplished. Kate won't have to obtain that conservatorship. She's going to be able to privately deal with things on my behalf. Here's the thing though, if a third party does not want to accept my power of attorney, then they don't have to. Third parties are litigation conscious and they are increasingly reluctant to accept powers of attorney. So if any of those third parties that Kate has to deal with on my behalf don't want to take my power of attorney, they don't have to, and Kate's back to square one, having to head up to the probate court and obtain that conservatorship for me. But again, for the sake of illustration, let's say that prior to being rendered incapacitated on my way home, that I had a living trust, and I had all my accounts, all my property in my living trust fund prior to becoming incapacitated. A properly drafted living trust agreement will not only say what happens to our property in the trust at our death, but also what happens if we're incapacitated. And so if I had a living trust, which I do, and if all my assets were in it, and I'm incapacitated, my trust agreement says, well, if James's attending physician says that he can't manage his affairs, well, Kate takes over. And then from my incapacity, I talk to Kate. I say, Kate, you taught me after we got married that what's mine is yours and what's yours is yours, and I'll maintain that. So I can say, Kate, if I'm incapacitated, use what I have to take care of me, but take care of you, and take care of the dog and the cat, take care of the kids. Continue to tithe the church for on my behalf. In sum, the living trust allows us to frame up a private, contract-based, system by which we direct how our affairs are going to be managed from the grave without third-party involvement. That's how we protect our family in the event of our incapacity. Well, planning for our incapacity is not the most fun thing in the world. We get that. We handle this sort of thing all the time. We can help you wrap your head around it, plan for it in ways that will give you profound peace of mind. Please give us a call. We'll be glad to answer your questions. 864-228-7808 or sclegacylaw.com. Thank you.